Okay, I have 7 o'clock. I
Yeah,
would like to call the Brimfield Township Board of Zoning Appeals for Wednesday, December 16th to order. If we could please have a roll call.
Okay. Bruce Nippenberg,
Here.
Scott Etling,
Here.
Vince Madacco,
here.
Ed Schutte,
Here.
Sean Phillips,
Here.
William Kramer,
Here.
Clayton Popick.
Here.
And also present, we have Mike Ladd, Economic Development Director and Zoning Inspector, myself, Zoning Secretary Lauren Kaufman, and Brian Gardner, our IT Director.
As well
Thank
as
you.
Mark Cadetti, the Township Attorney Mark Cadetti as well.
Minutes from November 18th. Everyone have a look at them.
Yep. I make a motion that we approve them as presented.
I'll second that.
You beat me to it.
We have a motion and a second. All those in favor signify by saying aye.
Aye.
Aye. Any opposed? Any abstentions? All righty, thank you. And we have an agenda for this evening. Everything on the agenda been properly advertised and notes sent out? And
Yes.
yes, okay. So, and there's no changes to the agenda as I'm looking at it. So we have a motion on the agenda.
So moved.
I'll second.
Okay, we have a motion and a second to accept the agenda. All those in favor signify by saying aye.
Aye.
Aye. Any opposed? All righty. We basically have two things on the agenda this evening. A conditional permit for sheets and a conditional permit for, let's go to the bottom. Lemon Development LLC. Okay, is anybody here this evening to speak on behalf of Sheets, or shall we move right to their request for? Okay, no one's here, so if we would,
I don't believe that they were, I think they, when they sent in, oh.
No, I was going to say, I did speak with Sheets' attorney this morning. He called just to confirm that the township did in fact receive the request. And it sounds like they're asking that the matter be continued or the applications be considered at the January meeting of the board.
so if we want to continue, we also need to allow the extension of time. As pointed out earlier, there's a 60-day window to act on the application. So do we have a motion in favor of the applicant, or?
So we're just extending the deadline for the application, is that right?
Yeah,
Yes,
they're not,
until our next meeting.
Right. So,
yeah, it's just extending your vote and to get them, so they're looking for approval from ODOT, and they think that that's very important to their pleading their case to you guys to have all the evidence there. So I believe, we should wait until they get to provide everything they have.
okay, I make a motion that we extend their deadline until the January meeting.
I'll second it.
That would include the continuing it till then as well?
Correct. Continuing.
Okay. All right, we have a motion to continue and extend the Sheets applications until the January Zoning Board of Appeal meeting. All those in favor signify by saying aye.
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 Aye. Any opposed? Any
Lauren,
abstentions?
Lauren, can you do a roll call on that as well after each vote? Some of the trustees requested that we do a roll call after each one.
Okay.
Oh, okay. Okay, so Bruce Nippenberg,
Yes.
Scott Etling,
Yeah.
Vince Madacco,
Yes.
Ed Schutte,
Yes.
Sean Phillips,
Yes.
William Kramer,
Yes.
Clayton Popick.
Yes.
The next application is a conditional use application, Lemon Development LLC. Conditional use for a multifamily home or dwelling in the, I believe it's the IC district. Who is here to speak on behalf of Lemon Development?
Rich Costin. I'll be representing the Lemon Development Group tonight. Also will be joining us, I'm not sure if he's on, but our engineer will be available, John Walsh, if he's needed for any technical questions.
I believe
Okay.
we have two attorneys as well. If you guys want to introduce yourself, Marcus and Frank.
Sure, I'll go first. My name is Marcus Pryor II. I am an attorney and I'm representing myself. I am the landowner here in the Sterling Green neighborhood, 4237 Whitestone Road, Kent, Ohio, 44240. I'm appearing in opposition of the applications.
All righty. Then if we would, I have swear everyone in for this evening who's going to be speaking, either on behalf or opposed to.
I think there was,
And
Mr.
then
Chair.
I'll read it, and if you agree, say I do when Ms. Kaufman calls your name.
I think there's one more, Frank. I
Oh,
think
I'm sorry, go ahead, Frank.
That's all right. Thank you. My name is Frank Semino. I've been here for a little while down in Ravenna. I've been law director since 1976 for the city. And I'm here on behalf of Mike Casamento and also John Flynn. They are the owners of the two parcels of land. John is believed to be zoned HC and Mike's is IC. But I am here on their behalf as the landowners and representing them.
And then,
All right.
Mr. Chairman, we have one more on as well, and that's Todd Peets, Regional Planning Director for Portage County, to help out with and assist as well.
Thank you. All righty then, if you would, do you solemnly swear or affirm the testimony you will give before the board is to the best of your knowledge an accurate and truthful presentation of the facts? If so, say I do as Ms. Kaufman calls your name.
Marcus Pryor,
I do.
Frank Semino,
I do.
and Todd Peets.
I know he's home with his kids, so hopefully.
I do, sorry.
All righty. Mr. Zoning Inspector, do you want to start us off with what it is that's going on here?
Yeah, so this is a conditional use in an integrated commercial zoning district. So we've been doing a little bit of homework. With the application, I did request first and foremost out to his engineer because the application didn't provide the statement from the get-go. The engineer did provide a statement, but then it didn't say anything about being harmonious with the existing conditions. We did receive that. You did get emailed all that as well as it's on the website today. So we do have a completed application at this point in time. But the section 311.02B1A states, for residential use, multifamily dwellings up to a total of 12 units per acre, subject to the provisions of Chapter 4 and Section 400.10B, subsection 53. So it is a conditional use in the integrated commercial district. The comprehensive land use plan, the last update, we're working on one right now. As you know, we won't be done till the spring. The last update we had was 2004. And also this integrated commercial was put into place the same year in 2004 with the map. And Todd Peets is here from Regional Planning that could discuss some of the history on that as well. Todd, if you're still there.
Okay, so sorry if you hear my son in the background and stuff, but so as Mike stated, the IC district was created as a result of the 2004 land use plan, which was before my time. But prior to that, there was other zoning in this area, none of which were low density residential. They were either highway commercial or a general commercial or a combination of those two. But that's the history of it. It was, this area has always been kind of in that, close to proximity to the interchange roughly, and definitely close proximity to I-76. But like I said, the most recent, the way this property was addressed most recently was in 2004 land use plan, and at the time with a zoning change. And also, as Mike said, we're working on the update to the land use plan now, and so we'll be addressing this area more directly at that time. We just haven't had anything to take to, we haven't taken anything yet to the zoning commission, and obviously it's all still a work in progress. So that's that consideration is still pending on how that might change.
Now so part of the property is on highway service or on highway commercial, the HC district. It's not conditionally permitted in that area.
So they would be coming in under uses not covered, and Rich Costin is here to explain. I believe that's more of roadway, correct, Rich?
Yes. If you want me to jump in, I can. But yes, that is more, that piece of land is the smaller piece. It's the second item on our list here that we're asking for. And that is mainly to get a road connection out to Route 43. And so it's a small parcel. We can get some villa units on there. And so, yes, that is what we're asking for. But it goes with the project. And, it could be together. And that's why we thought it was a better way to do the project, to try to get some of that traffic out to 43.
Okay. All right. Do we have any questions yet from the board? All right, we'll go then to the applicant. The floor is yours. Please tell us exactly what it is you're expecting to do and why you think we need 12 units per acre in that area.
Okay. All right. First of all, my name is Rich Costin. I'm with Lemon Development. We have the property under contract. We are proposing a market rate apartment project, which would include garages, a community center, other amenities such as dog park, fitness, etc. We are proposing a maximum of 216 units. They would be garden style, residential type buildings. We would include buffering, such as mounding trees, mainly along the abutting the Sterling Green neighborhood, because the rest of the property abuts either Interstate 76 or just open space or back of other land, kind of thing. So proposing mounding and trees there. We do feel this is an ideal location for an apartment project with its proximity to the interchange, and just it's off of 43 there, which is a major artery, and that's why we think it is a good location for an apartment project. And we have two items.
I don't mean to interrupt you, Rich. I just want to jump in here really quick, and I want to just make it clear, as you guys are looking at the drawings that were submitted and the things that are online. He is coming for the conditional use only. There is variances that will be needed if the design stays the way it is right now. But that will be dealt with as we do a more detailed review and see if this conditional use gets approved or whatever happens here. But after that point, he will have to come back in for variances if the design stays the way it is.
Okay. All right. Thanks, Mike. I didn't know how far to get off or stay focused on that. That's why
Go ahead, stay focused. Yeah, I'm sorry. I just want to make that clear because there's some that are out there that you can see. It's like, oh boy.
Yep, I understand. Okay, well, we have two items. We're asking for two things tonight, which we started to touch upon. The large parcel is in an IC district, and it allows for high density, and that is where we were asking for the conditional use. We feel we are meeting all of the criteria for the conditional use, including being harmonious to the area, harmonious to the area. There is already another apartment project in the area. Our apartments are a residential look and style. In other words, there's some brick, vinyl siding, shingled roofs. Again, they're residential in look and style. The second thing we were asking for is on the smaller piece. And again, that is zone HC. And the main reason we're asking for that is to give a secondary access connection to the project to Route 43, which is the major route. And then along that, we can fit some villa units in there. Those are villas, so they'd be like single-story slab on grade. There's just 12 of them there, only accessing one side of the driveway. So those are the two items that we're asking for tonight. And I'm here to answer any questions you may have.
Now, the structures you're talking about, are they single level or multi-level?
No, these will be 3-story wood type structures. I don't know if anybody's familiar. We own Yorkshire Woods off of Howe Road in Cuyahoga Falls, and those are garden style apartments. There is, I think anywhere else there's on the other side of the highway there's 3-story type buildings, but wood construction, 3-story, stairs, no elevators, open hallways, corridors, and the garages are detached.
And then your main egress, ingress is going to be Town Square Drive onto Kelso Drive?
That is correct. Again, the second thing we were asking for is to have that connection out to Route 43. There is some limitations with the access out there, but yes, that is what we're looking for, is to get the secondary access out to Route 43. We think that'll be important to maintain, helping with the overall traffic of the area, having that secondary connection.
I think with the traffic, I think that's going to be a tight, that's going to be, I don't know, Town Square Drive, so it's really close to the interchange. You've got Vans, Wendy's, and Speedway all trying to dump out in the same area with no signaling. And then if the main entrance is off of Kelso and Town Center Drive, you're going to have a lot of traffic in and out at Kelso Drive. And we were just having discussion last month about concerns at traffic at Falcon Drive. So I feel like we've got a lot going on in this area with no promise of any type of additional signaling from ODOT. Do you guys have any traffic studies from ODOT, or have you submitted any to them?
To ODOT, no. We're kind of taking this one step at a time. We want to make sure that we, can get conditional use at the project, that we're allowed to, build the density that we want to build. I am sure through the normal planning process that, somebody would ask for a traffic study, and we would, obviously have to provide that. But no, we have not done anything to date with that. One thing with traffic, you have to have the need for it before they're going to put signals in. They just don't want to put traffic signals in at every intersection with someday. So projects have to be there. The traffic has to be there to warrant signals and so forth. So hopefully that answers your question.
The second road out will be where?
I don't know if you have the drawing in front of you. It will connect to Town Square Drive.
Okay, that's.
So that'd be going west. We have the if we're coming in off the Town Center Drive, which is the cul-de-sac behind Sterling Green, we'd kind of meander through our project, and then we'd go west, kind of up the hill, and then come out onto Town Square Drive, which somebody may have to help me with what's all up there. But like you said, be north of the Wendy's and south of the
okay.
station.
I wasn't seeing the route next to Wendy's.
Okay.
Okay. Okay, do we have any other questions from the board at this time?
You heard anything from the police chief or the fire chief?
We have letters on sheets, but I don't have any letters as far as.
Not on this project?
But I do believe you have some letters from the trustees as well. I believe two of the trustees, Nick and Mike, have wrote letters specifically.
Yeah, because,
but
go
I
ahead.
address departments as well.
Because that's a good point about the traffic. I mean, this was the same conversation we were having last week or last month. So I guess my concern is how, the same stipulations that we were holding sheets to, how do we bypass them with this?
I guess part of my response with the traffic, I'm not a traffic engineer, and traffic engineer will be brought in. I believe when it goes through the review process at the county, I believe that someone's going to ask for one and they will have one. Traffic, studies are there are science behind it. There's a lot of counting and times of day with traffic flows. So I again, we just don't go nobody goes in and put traffic signals unless someone says it's warranted. Route 43, I mean, there's been some major improvements there. That is a big road to handle a lot of traffic, and that is what I think the point should be, that they're trying to get this to 43 is very helpful, and it's designed to handle a lot of traffic. One time that skipper group that all across there, and that which has never been developed, but there's a lot of capacity up there from what I can see.
Well, one of the arguments that was going on with Sheets was that the town center there was never designed to handle this much traffic as there is now. So we're adding more to it. So that I'm just vocalizing a concern. That's an additional concern.
Yeah, that's to kind of speak what Scott just said. 43 is designed to move traffic through the area. Getting traffic on and off 43 right now, especially in that 2 or 3, if you want to call them block sections, can be very dangerous. And that was what a lot of the discussion was built around last month.
If that's all you have for the moment, Mr. Marcus, would you like to, you're in opposition?
Yes, thank you,
You have the
Chairman.
floor.
Yes, thank you, Chairman of the board and associate board members, for allowing me to appear here and be heard today. May it please the board, as you said, I said earlier, my name is Marcus Farrar II, and I am an attorney representing myself here today as a neighboring landowner of the proposed conditional use applications. And while I am representing myself and my family, I know that my neighbors in the Sterling Green neighborhood and many residents in the township all oppose this application, as evidenced by the more than 20 pages of letters of opposition that are on this board's website. That said, I requested to be heard today because my opposition is rooted in the legality of the conditional use applications here today, as opposed to the general opposition that has been rightfully expressed. And so I apologize in advance because my wife swears to me that my argument is too attorney-ish or too much written legalese, so I do apologize for that. But I do hope that the board appreciates the legal framework in which it is bound to operate as a quasi-judicial administrative body that is essentially a court. And as such, this board is charged with making decisions and rulings that have the force of law. So, and of course, this board's authority to act is defined and limited by the Ohio Revised Code and the zoning resolution itself. And so I want to turn to my legal argument. I know that this board is aware of section 400.10 of the Brimfield zoning resolution and the board's obligations to make findings of fact in response to the, I think it's 33 evaluative criteria outlined in subsections A and subsection B. As such, I argue that as a matter of law, meaning no matter what evidence the applicants submit now or even in the future, neither conditional use application may ever be approved by this board, because there's no way that this board can make a finding of fact that the conditional use applications as submitted will ever comply with the second evaluative criterion of subsection A, section 400.10, which I attached as Exhibit A to my legal brief in opposition. And if it's okay now, I will share my screen so that you all can see my exhibits. And can you all see that there?
Yes.
Okay, so this is Exhibit A. It's Chapter 4 of the resolution. And you can see we're in subsection A, number 2. And just give me a second to move all off of it. So the second criterion I've highlighted here is that it will be, any conditional use application will be harmonious with and in accordance with the general objectives or with any specific objective of the Brimfield Township Comprehensive / Land Use Plan of current adoption and the zoning resolution. And so I now turn to the land use plan, which admittedly before this application, I had no idea existed. And so I actually had to go to the county itself to get a copy of it, because as you all already been made aware, the last time the plan was amended was 2004. And I want to introduce now Exhibit B, which is the current plan, the 2004 amendments that I'm showing on the screen. And so in order to be harmonious with and comply, I'm scrolling down to the goals and objectives as outlined in 2004. You can see that the goal number 1 is that multiple residential districts by density patterns be placed in an area in such a manner that are compatible to one another based on topography, geographic trends, and transportation access and current availability of central utilities. I've highlighted the important part here, which is that moderate to high densities should be predominantly situated along State Route 43 and the lands north of I-76. And so I turn now to Exhibit C. This is the current zoning map as of 2016. And again, this was Exhibit C to my legal brief in opposition. I'll zoom in a little bit here so that we can see Interstate 76 running horizontally here. And then we all can see State Route 43 running vertically. The land in question, the integrated commercial land right here, which I call Mr. Casamento's land, and Flynn's land right here. Mr. Flynn's land is right next to it. Both of these lands are south of 76. There's nothing that the applicants can do to change that. There's nothing that will make them otherwise compliant or harmonious with objective number 1. Now, the other argument or position is that it must be off of or along State Route 43. And again, we can see right here, everyone can see, this is not on or along State Route 43. It's away from it. And so we know that there's a current plan underway, but until a new plan has been approved by the township or the existing plan is amended, the applicant's proposed conditional use to build multifamily dwellings, that is high density dwellings, high density residential dwellings in this area, must fail because it's not north of 76 and it's not on 43. Now, I also want to point out that the applicants have amended their applications, and I saw them on the board's website this morning. And I pulled up, I don't have this listed as an exhibit to my legal brief, but this is the amended application. And we can see that they kind of went step by step and addressed some of the criteria. You know, I know there's 33, and you can see through here, all 33 criteria are not addressed. But to the extent that they addressed the second one, which again, I think is a showstopper, their answer or their response is to quote the zoning resolution. And I do not disagree with their quotation or their position that integrated commercial does permit conditional uses so long as the 33 criteria are met. But what I point out to the board is that the quote to the zoning resolution still fails to address the land use plan. There's nothing that they can do. There's nothing that they can say. There's nothing that can be submitted that gets around section 400.10.A.2 requirement that the land be north of 76 for high density. And so therefore I argue, and I take the position that as a matter of law, again, meaning no matter what they say or do in terms of evidence, these applications must be denied until a new plan is put in place.
Okay, is that all you have for now?
That's it for now.
Okay, do we have a rebuttal?
I'll stop sharing here.
Well, I would like to say something on behalf of the landowners.
Go ahead.
Again, this is Frank Semino, and I appreciate your hearing me. First, I guess I'd like to thank Captain Pryor for his service to the country. It's very impressive, and I want to recognize that. Now, the bottom line on this, as far as I can see, is that both the HC, Highway Commercial, and the IC, Integrated Commercial, have the conditionally permitted uses. So they are permitted as long as the conditions are met. And I think that the first one, dealing with the highway commercial, deals with the idea under 310.02B12, and it says any uses not covered come before the Board of Zoning Appeals for a ruling. And that's basically where we are on that 1.95 acre parcel of land that's zoned HC. The second parcel deals with the integrated commercial, and as Captain Pryor indicated, section 311.02B1A indicates that multifamily high density can be approved as a conditionally permitted use up to 12 dwelling units per acre. And so both of those provide you with the jurisdiction to grant these bases on which to develop this property. So there's no question that under your zoning ordinance, you have the authority to do this. Now, I would indicate to you that the IC purpose, when you look to the very beginning paragraph of the integrated commercial, lists high density multifamily in two separate instances in the purpose of the integrated commercial. So it is something that is recognized again specifically under that zoning code of yours. Now, I am concerned about the obviously the issue that was raised by Captain Pryor in relation to paragraph 2. And he indicated that the development as a condition is to comply with the comprehensive land use plan. Now, I think you have to look at the history of this, because in 1988, you had your first, as I understand it, comprehensive land use plan. Now, in 2004, the document that was marked as Exhibit B by Captain Pryor modified that initial comprehensive land use plan. And in that, it created, for the first time, the integrated commercial district. Now, just for the sake of discussion, when a zoning code, your zoning code was amended in 2004, your zoning commission first had to look at it. And they had to then hold a public hearing to move forward. From there, it went to the Regional Planning Commission, and they had to review it, and they had to approve it. So both now the Zoning Commission, after public hearing, and the Regional Planning Commission had to approve it. Lastly, it went to your trustees, and your trustees then had to hold a hearing on it. And this is the zoning code from 2004, which created the integrated commercial. And that again required a public hearing. And after all of that, perhaps 6 to 8 months of review, the zoning code as it currently exists was implemented. Now, I think it's important to note that the comprehensive land use plan and paragraph number 4 under 410.A, second paragraph, had that paragraph in, or that sentence in there regarding the compliance or conformity. Well, obviously, there is a direct conflict between what the zoning code says and what the what the section 400.10B2 A2 indicates. What I would indicate to the board is that in order for that to be functioning, your trustees, your township created this district, even in light of the wording that's in 411B, 410A2. And as a result of that, they had to have taken that into account in the manner in which they created the zoning district. I think another aspect of that is, in my opinion, in reading legislative enactments, the general is always governed by the specific. And in this instance, I would argue to you that 400.10A2 is a general statement. And the actual zoning code itself is very specific. It tells you exactly what you can do on that parcel of land. Now, granted, it's below 76 and it's adjacent to 43, but it's below 76. But it was a decision made with full knowledge of the comprehensive zoning or land use plan and created in that fashion. So I would argue to you that it is not inconsistent with that plan because it was done in full knowledge of it. And as a result of that, I do not believe that it is anything inappropriate based upon what this township did at the same time. Now, I would indicate to you that the plan, if we look back to that exhibit, I believe it was B, that Captain Pryor referenced, there is a paragraph on the bottom of the first page. And it says, and it's talking about the plan, the exhibit that's from 2004. These same concerns were the apparent findings of the 1988 land use plan. However, some of the land use goals, objectives, and policies of the 1988 land use plan were never implemented through the various revisions of the zoning resolution in subsequent years. So I would argue to you, and I would perhaps fall back on Mr. Peets, that the land use plan is a guide. It's something that sets forth what your goals are, what you might like to see as the future develops. But as it exists, it's something that is land use, the comprehensive land use plan is something that is kind of a guide, some type of goal for the future. But when you look to what is permitted, there is no question that it's the IC district that has been created and that is available to these individuals for their development. I would think that based on that, there is no question that this is something that can be done. And I would indicate to you that I believe Mr. Peets available? Is Todd available?
Yep, yes, I'm here.
Todd, I just ask you, as far as what I indicated to the board, would there be anything that you would correct in relation to what I said regarding the comprehensive land use plan?
Yeah, I think I would correct one thing. I mean, and it's not something that you said. I think it was the other gentleman who mentioned that everything has to be north. All multifamily has to be north of 76 or on 43. The key word is predominantly. So to me, predominantly means the desire is north, and the majority should be north. But I don't think it shall be north or shall be on 43. I think that's how I would read. That's how I'd interpret with the word predominantly in the land use plan.
And I did forget the word predominantly. I apologize. So I thank you for that clarification. And I think it's an important word also, that it did not exclude that anything could not be done south of the interstate in relation to the high density multifamily. And I guess I'd also point out to you that in the R4 district where Captain Pryor's home is located. Multifamily is a permitted use in that district, and it's also a conditionally permitted use, so that you have you can increase the number of multifamily units even in the R4 district if you go to the conditional provisions of that particular zoning code. So I guess that's what would be my response to the captain's position in relation to Article or Section 400.10A2. So I would not say anything further at this time, and I guess request some additional time based upon what else is presented this evening.
I have a question then regarding going back, Mr. Pryor, Captain Pryor's comments. You did amend the application and go through the first 11 questions under Section A. But then there was Section B, the specific requirements of conditional use, and none of those were replied to. Specifically, I'm referring to number 8 and then number 9. I'm assuming number 8 should be cleared up if we okay the Flynn property, that such developments should have primary access to arterial streets or be located at intersections of arterial or collector streets. The second one is such development should be located adjacent to non-residential use such as churches, parks, industrial and commercial use. And it's actually adjacent to two residential areas as well as the highway use. And it's permitted, as it right now, you're permitted 4 units per acre, with the conditional uses being 12. Do you have any comment on that? I mean, I just look at it being harmonious. You have all the single family dwellings south of you, and all of a sudden you want to put in high density dwelling in that area when you are permitted 4 per acre as opposed to the 10.
Are you addressing that to me, sir?
You or the developer.
Developer, okay. Well, I'll let Mr. Costin address it first.
Rich, this is John Walsh. Mr. Chairman, I'm with GBC Design, and we're the author of the plan and the response letter that you're referencing. And I guess the way I had interpreted your zoning code is that this conditional use is subject to Section 410A, and under that there's 1 through, I believe, 11 items that it is to be reviewed by. And then the way I interpret Section 311.02B1 is a multifamily dwelling up to 12 units an acre, subject to the provision of Chapter 4, Section 410B, subsection 53. And I guess the way I interpret that wording, that only Section 53 is to be used to review and judge this conditional use.
But it actually states, as you said, provisions of Chapter 4 and Sections 400.1B.
But then
and that's what I'm referring to.
Yeah,
401A is general requirements, and 400.1B is our specific requirements.
Right, and I guess the way I understood Section B is kind of a collection of everything that could be a conditional use in the township. Let's just say it's a junkyard, and if it's a junkyard, there's a certain section of B that's applicable to junkyards. That it's not the whole code, the whole section is not applicable to junkyards. In this case, the only subsection of B that's applicable is 53. And I apologize, I need to pull your actual zoning code up, or I don't have the full sentence there.
If I may interject, I think under Chapter 4 conditional use requirements, Section 400.10, general requirements for all conditional uses, in addition to the specific requirements for conditionally permitted uses as specified in section 400.10B, the Board of Zoning Appeals shall review the particular facts and circumstances of each proposed use in terms of the following. So I think A talks about the 11 items that are to be addressed. And it says, in addition to those, you have to go to the ones that are specified in section 400.10B. And when you look to the code section that deals with that under 11, it talks about multifamily dwellings up to a total of 12 dwelling units per acre, subject to the provisions of Chapter 4 and Section 400.10B, subsection 53. So I believe that the comments that were just made as far as how he interpreted it, I think he would be accurate, that you're really limiting it to the specific subsection of 410B that is being itemized in B1A under our 311.202. So I think that's not a bad, I mean, I think that's an accurate interpretation.
Chairman, if I can jump in here, just taking a look here, and I'll share my screen again with you, I would argue in the opposite. Give me 1 second to figure out how to share the screen again. So when we take a look at section 400.10.B, we can see in no uncertain terms, it states right here, every conditional use shall meet the following specifications as specified in Chapter 3. In addition to the general requirements as specified in section 400.10.A. So I can understand maybe the confusion as to whether or not you have to address all 33, the 11 and then the 22 in section B, but the zoning resolution is black and white. It says you have to address all of them.
Well, I think that what they're saying under A is, in addition to the specific requirements for conditionally permitted uses as specified in 400.10B of the board shall review in particular the circumstances of each proposed use in terms of the following general requirements. So to me, A sets forth general requirements. B sets forth specific requirements. So when the code section indicates that you're to go to section chapter 4 and section 400.10B subsection 53, those are the specific requirements that then have to be met in addition to the general requirements set forth in 1 through 11 of A. So I do believe that that is a proper interpretation of what you have in front of us.
So, Mr. Chairman,
okay, go ahead.
I would just note, you know, the language is a little bit vague, could be a little more accurately worded. I think the question is how the board has applied this traditionally in the past. And it sounds like at least some of the elements set forth in subsection B have been required to be met by the board.
And which ones are you referring to?
Everything after the initial 11 set forth in B.
Yeah. But if we go back to section B, I'm on page 84 of the code. It says in addition to the general requirements as specified in section 410A, every conditional use shall meet the following specific requirements as specified in chapter 3. And
Right.
chapter 3 only specifies section 53.
When I'm looking at it, same type of thing, but if you'll continue down to, let's start with page 87.
Yeah.
I'm sorry, let's go up to page 86. Right after the 22, there's some intentionally left blank area. It specifically has a 35 adult bookstores. And then on the next page, it has agricultural use. So the way I am looking at it, I'm looking at all of the first 22 in B are specific conditions that can be applied to any project that comes in as a conditional use.
Well, all I would say is I don't believe that's an accurate interpretation, of what your code says. But the bottom line is that the authority for you to act in this case is set forth pretty clearly in each of those two code sections, 310 and 311 under O2, that says what are conditionally permitted uses, and that you have the authority to do that.
So as a conditionally permitted use, what items are we talking? I mean, are they, in the beginning, you indicated that you were talking about, I don't know, some open space and so forth, tot spots, whatever. The conditional, I mean, like I said, it is permitted. You can get 4 units per acre. What would be the difference, I guess, in the two designs that would encourage us to look at it as a conditionally permitted use?
Well, in all honesty, I don't think there's any question that it has the ability to be a conditionally permitted use. All right. I don't think that there is any question about that, because under the B1A, it specifically says that is basically the only conditionally permitted use that is existing under the code. As far as the under 10, and under 310.02B, B12, it says you have the authority to go ahead and consider any other use under that conditionally permitted basis for adding that zoning to the property, or allowing that zoning to occur on the property. So both of those sections apply. I believe very strongly that the application that has been presented to you addresses under A, the 11 requirements that are set forth, and then under the section dealing with section 53 addresses every one of those requirements as far as having been met. And I think that the bottom line as far as Captain Pryor's objection is, I don't believe that is the historical manner in which that has been addressed under your code. I mean, they were both simultaneously adopted by your council, your trustees, and there is not a contradiction. I think, basically historical aspects of it, but predominantly, the word predominantly also is very significant and certainly does not preclude the only zoned district that you have, IC, that allows multifamily to be constructed on those two districts that have been established. They are both south of 76, and the language itself does not preclude, because we're definitely using the word predominantly as something that would be precluded.
Mr. Chairman, I have a question.
Yes, Fred?
How close are these proposed buildings to these single-family residences? What's our geographic distance?
I can let the developer answer that, or I can answer it myself.
I'm listening.
Okay. Well, there's multiple buildings, so there's different distances. So, John, you might have to help me, but the closest one would be the building setback of 35 feet from the property line, plus the 5-foot existing landscaping buffer, so 40 foot. And then the next buildings are all, I don't have a scale, but we're 70, probably 100, 120 feet from the property lines.
And perhaps
My
I
next,
can,
my next question is for the zoning inspector. Within the township, do we have an example anywhere in the township where we have permitted this type of density next to single-family housing?
Well, you have apartments right there right now. See, they're right next to the elementary school.
And
Those were in before zoning, I believe. You're talking about
I
the,
believe so too.
Those were in before the school as well.
right. Well, they were there when the old school was there.
The other part I would say is probably Copper Creek, where you have the Prescott Pike, where you got the mix of high density and residential and condo use.
Was that not approved for that particular type of usage 20 years ago?
No, so that was approved recently before I got here in the Open Space Conservation District was our highest density. And then Todd Peets and I, when I came in, I said, there's something god awful wrong that all these apartments in our highest density area is in open space conservation. So we did make modifications in that area to the zoning map as soon as we could. And then we, started going forth with the comprehensive land use plan. So that doesn't happen again.
Okay.
if I may, share my screen again. I know that the representative for the developer was talking a little bit about the distance as to how close they are to the residential homes here. Give me 1 second to share the screen. So I have here a picture. I apologize. I also filed a lawsuit seeking to permanently enjoin the applications here. So this is Exhibit F in the lawsuit. This is a picture of my backyard and how close the residential or the proposed apartment complexes would be. Literally across the width of a side street.
18.
I can put that back up if you are still looking at it. I apologize.
Yeah.
Okay, give me 1 second here.
Yeah, for what it's worth, I used to live over in Chapman Farms, which is right behind Sterling Green there, and they're going to be very on top of each other.
You go to the Brimfield Plaza.
So as you're looking at that, I do want to address the representative's point in regards to subsection B's requirements, those 22 requirements, to the extent that the applicants have not addressed those yet. You know, that's something that the applicants can come back and do, whether it be next month or amend their current application. So I wouldn't split hairs over the fact that they haven't done it yet, unless they say they're not going to. That said, I return back to the main point under section 400.10.A.2. And I agree with everything that's been said, especially with the word predominantly. It is a guide, as Mr. Casavento's attorney has pointed out. It is a guide that this board should use. And so if the guide says that high density dwelling should be north of 76, my position and advocacy would be for this board to follow the guide. The argument that the specific should govern the general, again, supports the interpretation or the application that, generally speaking, the regulations permit high density dwelling. I do not dispute that.
Hello.
Generally speaking, that is the case. But specifically following the guide, which I think we all agree is the specific here. Specifically, they're not permitted, or at least not encouraged, south of 76 or away from 43. And so for the points that have already been made, and as you can see through the other evaluative criteria, I would urge this board to make a finding of fact that no, high-density dwellings should not be south of 76 in this situation. And I'll stop sharing if everyone's had a good look at my backyard and my son's idea for going sledding with no snow.
Yeah, I guess if you could leave it up just for a minute. This was Rich, the applicant. I guess with that picture, you know, I point out, you know, if you do go look at some of our other projects, I did mention Yorkshire Woods in Cuyahoga Falls. You know, we would do mounding with trees to create a buffer, you know, from what he's looking at there. Now, unfortunately, that road, Town Center Drive, is literally almost touching his backyard. So we don't have, you know, I can't go on his property and do anything, but we can go on the other side of the street where he was looking at that piece of equipment. And I believe, other than the driveway entrances, we could mound and provide, you know, trees to block that. And you know, you can see in the background, those were the other apartments. I think someone asked earlier, is there apartments in the area? And those are the apartments that are that are already existing there. So anyway, that was just, I wanted to address or comment back on that about that we could do buffering there, and we said we'd do that.
Chairman, if I could just add in, you are correct in that those are the apartments there. Those are 2-story apartments. The proposed application here is asking for 3-story. So when you start looking in terms of privacy, enjoyment of the land, especially because the land back there is sloped upward, these apartment complexes would be literally looking down on my 2nd floor bedroom. Not only my bedroom, but the entire neighborhoods.
If I may, I believe that the issue in relation to the area, to be honest with you, is tremendously built up. There is all kinds of plazas and nursing care and other building structures that are just completely surrounding that. This is not, I mean, I appreciate the idea that, you know, the residential area is residential. I believe that from the mounding that's been discussed, you know, that can probably be addressed to cover and preclude the residential properties from seeing the development with significant mounding. I believe when I was talking to Mr. Casamento, there's apparently a lot of dirt that's there that can be used for creating perhaps mounds that would preclude any vision onto the properties. So I think that's something that could be addressed at a future point. But I think the concern that I have is I appreciate their residential properties, but there are all types of commercial structures that are in that area. And one other point that I would want to make is you have a piece of ground that the residential area is just a corner of this property. It does not continuously bound it all on one side. Just north of these residential properties is an open space. I believe they may have a retention area in there. Above that to the north is Interstate 76. As you go to the west, there are the other apartments that exist there. I don't know, but I believe they may be Portage Metropolitan Housing Apartments. There's the school building, there's a playground. There is a lot of development that's occurred in there that would not be at all, disturbed by what is occurring on this particular piece of ground. And I think that, you know, the area, as I said, north of where the residences are, that just covers a corner of the property itself, would be open forever because of that retention pond. I mean, that's always going to be natural in relation to that area. And the bounding, I think, would be able to suffice, you know, for the preclusion of the vision of the property owners, homeowners, onto the land that we're proposing here. So I think that there is plenty of ability to work with creating a situation that would allow this to be able to be developed, and in reality, an area that has had tremendous growth, tremendous commercial growth, and perhaps will continue to be in that area. If you get down to where the nursing home is, I guess I'd want to point out that that would be another way of ingress and egress heading down all the way down to State Route 18. That would be another. And there would be perhaps 3 different ways that that would be allowed to be done based upon the entryway onto 43, lower onto off of Kelso, and then down further onto State Route 18. I believe that the property avails itself to that. I guess I would have one last question, and if Todd is still available, I would ask Todd if he's there. Are you there, Todd?
I'm here.
I guess my concern with this is the feasibility of the development of this property. Would you be able to provide us with, as far as the, I guess, the expertise that you have in relation to regional development in our county? Would you be able to tell us what you would be, perhaps the type of development that would be best suited for this piece of ground?
Well, that's pretty speculative, but you look at it. If you didn't do a multifamily project there, I mean, I definitely believe that with these conditional use things, you need to make sure that compatibility and harmoniousness is addressed specifically to protect those residents who are impacted by it. But if you did, let's say you did something lesser. Then, what's being proposed, you might get a single family project that probably isn't as nice as Sterling Greens currently because of the proximity to the highway and the proximity to the PMHA's space. So, and that's all again speculative. I think a project that was properly buffered and provided, some amenities or attractiveness to those neighbors being impacted, such as trees and a berm or whatever it is to block the views of the things that might be considered negative, then I think that's a benefit to them because, I mean, again, they're in pretty close proximity to the highway currently. I'm not sure, what else is going to go there as a higher or best use that would be of a benefit to the neighbors anyway. If you put an office building in there, they're going to have an office building to look at. If you put, I don't think commercial will fit back there because of its proximity off the road. And again, I would be worried about single family not being of the same standard of quality as the current Sterling Green property. Again, all speculative. Again, Mike, whenever I deal with any conditional use, I always want to make sure the residents are properly buffered and the compatibility is addressed.
Thank you.
I would like to then just briefly go through, since you responded to the first 11. We've already discussed 1 and 2. Be designed, constructed, operated, and maintained as to be harmonious and appropriate in appearance with the existing or intended character of the general vicinity, and that such use will not change the essential character of the same area. I would disagree with your answer. I believe that it would change the area. You have single family use just adjacent to the area. Then number 4 will not be hazardous or disturbing to existing or permitted use. As you indicated in the photograph, you'll be using that road that's in this gentleman's backyard as one of the ingresses from your property. And with a number of 202 units, how many vehicles is that? Is it going to be 200, 300 using these roads every day? Will not be detrimental to the property in the immediate vicinity and the community as a whole. Again, if it were my home, I believe that it would impact the value of the property of those homes that are currently adjacent to your proposal. Number 6 will be served adequate by essential public facilities. I'm going to have to assume that all of this is covered by your project. Number 7 will not create excessive additional requirements at public cost for the public facility and services and not detrimental to the economic welfare of the community. Again, I refer to the amount of traffic that we're talking about going in and out of the area, the amount of traffic coming out on 43, the additional safety that we're referring to. I mean, anybody can jump in. I'm not the only one talking here. Well, I guess I am.
Well, Bruce, I would echo exactly what you're saying, because that's my first concern. We're sitting on a load of letters for sheets that they're objecting to the traffic patterns, the volume of traffic. I would also argue that, you know, a 3-story building in that area is not harmonious to the environment around it. That is a tight area back in there. Like I said, I lived in Chapman Farms when Sterling Green popped up. You know, it's definitely a congested area, and I think something like that's just going to make it more congested. So I would echo exactly what you're saying.
I would agree too, Bruce. I was, you know, looking at the plan, just the way the plan's laid out right now, and going back to Bill bringing up buffers, and I know buffers have been very important to us as a board when we come to, you know, deciding stuff like this. And there's 3 units here that are right up against the cul-de-sac of Whitestone and Parsons Drive that I don't think you could ever successfully buffer to make it feel like there's a separation between the 2 properties. I mean, even at 40 feet, you're talking most of that, you know, 35 of that 40 feet is parking lot, and then you put the hill and trees in, and I just don't see how that could be harmonious. At the end of Town Center Drive, you've got, you know, the 30 unit single building that's just kind of sitting there up against the buffer. So, I mean, I get what the captain's saying. It's you know, all you're doing is looking at the back of that building, and you know, I can't blame the developer, you know, the property owner for wanting to develop it, but at the same time, I think there's better ways that it can be done. Multifamilies, I think, definitely going to be the lesser of multiple evils that this commercial property could be used for. But I think going back to just the harmony of it and traffic and things like that, there's got to be a better way to do this.
And Bruce, I strongly agree with your analysis and opinion. You know, the township has been wanting for an extended period of time condominium units, which we do not have except for just Cricket. And would this not make a very good site for high density condominium type housing? Would you consider that?
Was that directed towards somebody?
Anybody who wants to, you know, comment?
I would assume towards the developer.
Okay, developer. How do you feel about that?
We work with what the market is and what the market wants. And we do not believe the market wants condominiums. We believe that the apartments is the, you know, best use for this property. That's our opinion, and that's what we believe. So we're not building condos anywhere. And I don't know that there's a whole lot being built in the general area in several counties. Not saying there's not isolated spots, but we just don't see condos here. So that's our opinion.
You know, to the extent that you're looking at alternative uses of the land, in the legal brief in opposition, I do make the position, or at least make the suggestion to Mr. Casamento, that he could always develop it in the same manner in which he did Sterling Green. Perhaps, I think there are 20 acres over there. So if you were to parcel that out into maybe half-acre lots, that would create 40 lots, sell them at $20,000 a piece. He's looking at $800,000 there for the land. I don't mean to get in the middle or caught up between the developer and Mr. Casamento in terms of how they're going to make money on the land or the best use for it. You know, I definitely will defer to the developer, Mr. Casamento, but that's just a suggestion. And to the extent that there's a market, I mean, half of the residents here in Sterling Green would jump at that opportunity to be able to build kind of their dream home, if you will, right behind where we already are.
I guess everybody's entitled to their opinions. I would also remind everybody this, you know, reason, zoning does happen and different types of zoning and stuff, you have to look at everybody's just looking at what next to Sterling Green. This property also abuts 76. It also abuts another apartment project, other spaces. So understand people don't want this with Sterling Green, but you're just, saying, all right, well, hey, I can push it over and let it be someone else's up against, the highway or against other apartments. There needs to be some kind of a transition at some point in time. And we believe this property accommodates that and with what we're proposing to do. So again, just our opinion.
And I think it's well known that there's also the elementary school there as well. I mean, you are correct. That's what's around here, but there's also that elementary school.
Yep.
Well, gentlemen, I would also indicate to you that this property has been for sale for probably 30 years, and nothing has happened on it. I mean, it's just been kind of withering in there. I think this is a great opportunity to allow a nice development to occur, and I honestly believe that the can be arranged so that it does provide that seclusion for the residential areas. I mean, nothing that's going to be there that is not going to create traffic. Nothing that's going to be there is not going to be able to create more involvement with other individuals. The bottom line is that this is a project that's now available. It's not going to be a project we have a lack of attraction and or aesthetics, and it's going to be something that would be beneficial to the community. I don't see how the zoning with which allows it, should be ignored.
I guess it feels almost as though we're in kind of closing arguments moments right now. And, I would, in closing, I would just point out it absolutely allows it, but it's got to meet certain conditions. And so that's for the board to determine the 33 criteria, whether we stick with just the 11 under subsection A, or if we allow the applicants to also address subsection B. It's within your power as the board to make the determinations of fact as to whether or not each one of these criteria are met by this proposed use. I position and posit to the board that the answer is no, it is not.
Well, I believe that the application is submitted, and there was the one most recently submitted, certainly addresses all of those criteria that are applicable. A, and then section 53. And I believe those are the ones that are applicable to this matter. And to the extent that the conditions as a result of that can be complied with by the developer, I believe that the project is one that does merit being adopted as far as a conditionally permitted use.
Mr. Zoning Inspector, you'd indicated there were also letters regarding this issue?
There is. They're all posted online.
Well, that's how I was looking for them it's underneath this particular meeting.
Yes, Lauren, can you give them the specific directions?
Yeah, it's under the Board of Zoning Appeals meeting documents. They are under Lemon Development Project opposed. It's near the bottom.
Thank you. I was having problems finding those.
Yeah, no problem.
Do we ask, has police, fire, and even school been addressed with this kind of, I mean, I calculated just off the top of my head almost 1,000 beds for this development. Are we able to support that kind of capacity?
They'd be 1 and 2 bedroom units.
Okay.
First, I think we do need we would need a motion to enter all of these letters. Looking to see if there are any that are in favor. But all of the letters in opposition to from the citizens of the township.
Mike or Laura, do you guys know how many letters total? There's quite a bit.
Total,
We'll scroll down through them, but just one.
26 total, and all of the ones that I received were opposed.
Yeah, that's what I see.
I would like a motion that we enter these into the record, if we can.
I'll make a
Someone would
motion
like
that
to
we
make
enter
that
the, I'll make a motion that we enter the letters by the community into the,
I'll second that.
Okay, we have a motion and a second to enter the letters of opposition into the record. Can we have a roll call vote, please?
Bruce Niffenberg,
Yes.
Scott Etling,
yes.
Vince Brodacco,
Yes,
Ed Shooty, Sean Phillips,
Yes, sorry, mute button.
Sean Phillips,
Yes.
William Kramer,
Yes.
and Clayton Popick.
Yes.
Okay. I guess unless there's any additional information or comments, I would like to call question on the IC property. This would be the Casmeno property. Anyone willing to make a motion? Okay. Do we have any more questions or comments then?
May I be heard? My name is John Flynn. I'm an owner of part of that land.
Yes.
The only thing I would say to the township is you basically made that property unusable. You know, it's 19 acres. It was always intended to, in my opinion, and my understanding, you know, to be the commercial heart of Brimfield Township. And, you know, that just like, of course, I have an office in Kent, and they're building 2 6-story apartment buildings behind my building in downtown Kent. You know, I restored the old post office courthouse. You know, what's it going to be used for? I mean, if you want to, you know, your main commercial area, you know, you went down on County Road 18, you know, with all the big box stores. But, you know, this was to be the heart of your downtown, and the heart of a downtown is to be where the residents can live. And it is a transitional piece of land in, you know, the residential development and all that exists along 43 there. And again, has been pointed out, you know, you bumper up onto Interstate 76, you can't put housing on there. You know, you don't have, you know, certainly big office buildings, you know, that are going to come there. I mean, I guess you could put hotels back in there, but, you know, hotels aren't really being built now either. So, I mean, again, it's just, you've just got 19 acres of unusable land, and that's what's going to happen here. I think that's unfortunate for Mr. Casamento primarily, who's tried to do what he can in Brimfield, especially with the Brimfield Plaza. And all that land on that, Captain Pryor's living on, all that development was owned by Mr. Casamento, and a good part of it has been developed by Lemon and Lemon. So I wish, you know, when you say, well, you can break those up into $20,000 lots, you know, the development wants to buy it so they can have open space. You know, if Lemon and Lemon don't buy it, they can buy it. So again, you just can't let that property be totally unusable, and that's what you're doing here. All right, I've said enough. Thank you.
Okay, thank you. I don't believe that the property is completely unusable. It is permissible for 4 units per acre. I just don't personally believe that it meets the, at 10 units per acre, that it meets the criteria even listed under the first 11 steps, at least half of those. That's my opinion. And maybe a project that, I don't know, at a lower density closer to the single family homes going higher but that's not what we're looking at. So that's my opinion. It's up to the board to either come up with a motion one way or the other, or continue the discussion.
So I will note for the board that I think Mr. Semino, despite representing the property owners, I think he fairly and accurately and objectively summarized some of the history involved here, the pertinent provisions of the township zoning resolution, and probably the likely interpretation, some of those provisions by the court in his initial statement. That being said, the board obviously does have the responsibility to go through the specific requirements of the code as you're doing. The board's noted a couple specific issues, including buffering and its impact on the neighboring properties from a privacy aspect. So at this point, the board can either choose to allow the applicant some time to address those issues, or the board could obviously call the question.
Anyone on the board with a motion?
So basically, Bruce, the motion would be they're looking for 12 units per acre, where the code issues or allows 4, correct?
The permitted use is 4. So yeah, the conditional use application is for 12. Your motion would either be to deny the conditional permit,
Right.
or to grant it.
I make a motion that we deny the conditional permit.
I second.
Okay, we have a motion and a second to deny the conditional permit. May we have a roll call vote, please?
Bruce Nippenberg,
Correct, to deny.
Scott Etling,
Yes, deny.
Vince Bordaco,
Deny.
Ed Shooty,
Denied.
Sean Phillips,
Denied.
William Kramer,
Denied.
Clayton Popick.
Yes, deny.
Have one additional application. That's the Flynn property, uses not covered. Is that something we want to consider as a conditional use on that property, or not? I look at it, I mean, I guess stating the same thing I might have said for over sheets, that in a way we're looking at spot zoning to allow residential use in that area. That to me is something that Mr. Flynn should take to the zoning board if they decide they want to make that, to change it to IC, and then that way they wouldn't have to worry about our granting use not covered. But that's the way I'm looking at it. If we have any other comments from the board.
I kind of agree with you on that, Bruce.
Okay, then I guess if we can call that question as well. Somebody have a motion to either approve or deny the conditional permit based on uses not covered.
I made a motion that we deny the conditional use not covered for the applicant.
We have a motion. Do we have a second?
Second.
Okay, we have a motion to deny the application for the Flynn property. May we call the roll call, please?
Bruce Nippenberg,
Deny.
Scott Etling,
Deny.
Vince Bordaco,
Deny.
Ed Shooty,
Denied.
Sean Phillips,
Denied.
William Kramer,
Denied.
Clayton Popick.
Deny.
That at this point covers it. If we have any other questions or comments? Okay, on the continue, do we have anything for the good of the order?
No, not at this time.
Our next meeting is set for January 20th. I guess that's it.
21
then.
already.
What's that?
2021 already. What happened to the?
21 already.
Yep,
Leave 2020 behind us.
Amen.
thank God.
I make a motion.
I'll entertain a motion to adjourn and wish everyone a happy and Merry Christmas and Happy New Year.
Were we going to approve minutes?
We've done that.
We have?
Yes.
You did.
We did.
You signed up for everything.
Okay, good.
Hey,
I guess and a happy holiday.
Bruce,
It got
Do we
past
have-
me there.
do we have to approve the minutes or the letters for the sheets deal? Was that something that we had?
That's all been, we voted to move that to next month
Okay,
at the request of the applicant.
yeah, I didn't know if we had to accept the letters, even
Okay, I don't-
though they moved
You
it.
could do it now or later, whatever your preference is. Usually best to do it with the applicant present, in case
Okay.
there may be more between now and then, so.
Okay,
That must be the law director.
I agree.
Yes.
Okay, so we're looking for a motion to adjourn.
I make a motion that everybody have a Merry Christmas and we adjourn.
You too. I second it.
All right, do we need a roll call for this one?
Yes.
Okay, roll call, please.
Bruce Sippenberg,
Merry Christmas, Happy New Year, and Happy Holidays. I agree.
All right, fair enough.
all right, Scott Etling,
Yes, Merry Christmas and yes on the adjournment.
Vince Cordova,
Yes, and Merry Christmas and Happy New Year.
Ed Sheehan,
Yes, yes. You guys have a great holidays.
Sean,
Hopefully it's done. It's gone.
Well, you did a very nice job.
Lynn Kramer,
Yeah.
and Clayton Popick.
Yes, and Merry Christmas.
All right, meeting adjourned.